recognize some of you guys on here. For those who don't know me, I'm one of the attorneys here at Herzl Law. I handle a variety of different roles. I do a lot of different things, but one of the areas I specialize in is collections and lien foreclosures. So that's what our topic is tonight. So I'm going to jump right into the PowerPoint, and let me share my screen. Hopefully that works. Let me know. Can you see the PowerPoint, Ellie?
Yep, you're good to go.
All right, very good. So I've done this presentation in the past. Some of you may have even attended last year's, but we're talking about best practices for collections, everything your association is going to need to know. We're going to run through a lot of different topics. Again, I'm Brian Halak. I'm one of the attorneys. I've been with the firm since we started in 2018. And here is a little overview of some of the topics we're going to get into today. We'll start by talking about the role of the board of directors. We have a lot of board members in attendance tonight. We do have some property managers as well, but I'm happy to see a lot of board members in attendance because it's actually important. Board members are a very critical part of dealing with the collection process, even though sometimes you guys don't want to. So we'll talk about different types of delinquencies, why you need a collection policy. We'll run through the timelines from start to finish on how a collection case gets started and where we move that forward at every step of the process. We'll go through the different options from a legal perspective once it gets to your attorney. We'll talk a little bit about the importance in having a lien recorded, why that's so important based on timing as far as priority between mortgages, unpaid taxes, condo liens, construction liens, etc. We'll get into, this is always a big topic, the differences between filing a lawsuit or proceeding with a foreclosure when trying to collect, and we'll talk about pros and cons of each. We will go through some additional options that you guys might have available to you depending on your documents. As you know, every association has unique provisions in their documents, and those are going to be your first step to look into when you're starting the collection process. And then closing off, we'll talk about the Step Forward Michigan program, which provides assistance to homeowners to pay off past due mortgages or assessments, bankruptcy, and some new issues that are coming up because of COVID-19. Like I said, if you guys do have questions as we go, feel free to shoot them in the chat. I will check that periodically. And if I don't get to it during the presentation, we will definitely do a section at the end where I'll answer all of your questions. So getting started with the role of the board members. One of the most important things that you have to do when you're on a board is, and oftentimes you guys will have management companies do this for you, but especially for my self-managed associations out there, keeping accurate records. This is extremely important. You're going to want to have accurate records of who are all your owners, what are their names, who lives in the community, who doesn't. You know, if somebody's renting out their home or they're a landlord or an investor, you want to make sure you have their offsite mailing address. You want to make sure you have a way to reach them, and you want to make sure you know which homes in your community are owner occupied and which ones are being used for an investment purpose. To the extent you can get it, you're also going to want to have email addresses. That's really helpful in reaching people, particularly if they're not at their home or when there are delays with the mail like we've had during this COVID situation. And then of course, keeping accurate records of payments. I see problems a lot of times with our self-managed communities where they don't have a professional management company and that type of software to handle all the payment processing. And we do see errors in the record keeping, and that can cause problems, particularly when an owner actually has proof that they've made payments, but it may not be reflecting in the association's records. And we've had situations where an account's turned over to our office for collection. We spend attorney fees trying to collect, and then we find out that the owner actually did make the payments. It was just a record keeping error on the association's part. And of course, in that situation, the association would have to eat the attorney fees and not be able to recover them because it was their mistake. So keeping your accurate records, very, very important. And this is not an easy task. So especially if you have a big community, and especially if you're not using a management company, I understand that this is a very tall order. So particularly when units or homes are being sold and you have to constantly keep up with the banks and the title company requests and keeping track of who's on the deeds. But this is important. So make sure if you guys are self-managed that you guys put that task in the hands of someone who's very organized and going to stay on top of it. The other thing that you're going to be doing as a board member really is working with your partners, and that's going to be mainly your property manager and your attorney in dealing with these collections. Just going to add a couple other people into the meeting. All right. So what else does the board need to do? Well, one of the most important things is you guys have to be on top of it. You cannot ignore it when somebody becomes delinquent. I can tell you it's a lot easier to go ahead and collect money when somebody's only a couple months behind and the balance is less than $1,000 than if you let it rack up a balance of $2,000 or $3,000 or $4,000 and you leave someone to get several months behind before you take action. So you want to stay informed. If you have a management company, they will typically send a report to the board, usually on a monthly basis, but says, here's our status of our outstanding receivables. Here's who's up to date and who's not. And you guys are going to want to make sure that you take a look at that. And people who start to become delinquent, we'll get into the exact timing in a little bit, but don't let people fall too hard behind. The other thing you're going to want to do is when someone is in a delinquency situation, as a board, you have to be flexible. You have to understand that every person's situation is different. So what might work as a result for some person may not work for someone else. So being flexible and keeping in mind that people have different circumstances. Someone may have lost a job. Someone may be going through a medical emergency. You want to keep those in mind and treat those situations in a certain respect the same by following your collection policy, but in a certain respect, you also want to be a little bit flexible. So, if somebody's a landlord and owns 2 or 3 homes or units in the community, rents them out for a profit, but just doesn't pay their assessments, you're not going to necessarily be as lenient with that person as you are with an owner who's lived in the community for 10 years, always paid their bill, but just fell on hard times and fell behind for a couple months. In that situation, you may be more willing to work out a payment plan, waive late fees, things like that. So always understand that you can be a little bit flexible, but you always want to treat everyone under the same process. And of course, final thing for the board, communication is key. So when it comes to communicating with your owners, with the members of the community, sending out notices of the assessment, sending out delinquency notices when someone's late, everything's going to want to be done in writing. And we actually encourage people to communicate via email. A lot of boards don't do this. I think it's actually a good practice. It's a way that we've been successful in reaching people who maybe aren't at the unit or their home for an extended period of time. We have a lot of snowbirds here in Michigan who travel down, to Florida during the winter and may not be getting their mail. So email, you'd be surprised. A lot of times you can get a hold of someone by email. They may not be getting their regular mail. And of course, you always want to be professional and you want to avoid confrontation. When you get into the role of the property manager, it's important to understand what their role is and what a manager is going to do for your community versus what they won't. A lot of boards actually expect their managers to do things that they're not going to do or that they're not legally allowed to do. So as an initial matter, whatever your management contract or management agreement says, that's going to govern the relationship. And typically what we see is the management agreement will say, hey, we'll process your payments. We will help you guys out with the budget. We'll send out the notices. We'll send out payment coupons, and we'll send out delinquency notices. That's standard, but that's usually the extent of it. Your property manager is usually not going to pick up the phone and call people to say, hey, you're delinquent. Why haven't you paid your bill? We have a lot of boards who want that, but I don't know of any manager who's going to do that or who does that. So you want to make sure your expectations are set in line from what your manager is going to do. You also, of course, the manager's role is going to be at your board meetings, usually monthly, but if it's not a condo, sometimes it's quarterly or less than that. They're going to keep you guys informed. They're going to send you the budgets, the financials. They'll tell you who's up to date and who's not. And that's very important because typically it's the property manager who's going to be dealing with the attorneys, going back and forth with the various homeowners on payment plans or legal actions. So The property managers will keep you guys updated, and that's something you should address at your regular meetings. And of course, the manager is going to be your liaison. They're going to be the middleman so that you don't have to knock on people's doors to collect money. Your manager's there, and you guys are paying them to try and do that for you by sending standard delinquency letters, referring the accounts to the attorneys, and dealing with all the payment plan requests. I just want to switch over really quickly to see if I have any questions in the chat. Ellie, do you know how I can see the chat when I'm sharing my screen?
I don't, but it doesn't look like you have any questions right now.
Okay, very good. All right, so what is a property manager not going to do? I've seen situations where boards will expect their property managers to do really what's considered legal work. Like we talked about before, the property manager is not going to pick up the phone and call owners and say, hey, you're late. Why haven't you paid your money? If you don't pay, we're going to sue you. So I would not expect my property manager to do that. And I don't know of any manager that does. Another thing that the managers really should not do is record liens or do anything along the line that borders on practicing law. So there are a lot of specific requirements that you have to be aware of when it comes to recording liens, what kind of language has to go in the lien, making sure you have the correct names of all the people on the deed. This includes a title search. It includes checking to make sure that people are not in bankruptcy. So there are a lot of different moving parts going on when someone becomes delinquent. Managers should not be recording liens or really doing anything other than sending the standard delinquency letters and then referring the accounts to the attorneys if not paid. So again, just keep in mind what your expectation is going to be from your manager and making sure that you don't expect them to do things they shouldn't be doing. Now, it's important to keep in mind that people become delinquent for a number of reasons. And a lot of the reasons that we see are listed here. And the reason that I list them out is because depending on what reason it is, the association is typically going to look at that case from a different point of view. So start with the first one, falling on hard times. Someone loses a job, a married couple gets a divorce, and there's only potentially one income for that household, or there's an unexpected medical expense. These are the situations where you would expect it's not a repeat offender. It's kind of a one-off situation. And obviously, you're going to want to work with your owners when this happens. But of course, still following your collection policy, which we'll get into. Another reason we see a ton of is investors and landlords. And, I think I saw a study the other day that said approximately 30 to 35% of all Americans rent their homes. A lot of those are apartments, but a lot of those are also condos, single family homes that people rent. And so there's definitely a huge market out there for investors and landlords that love to buy these properties up when they can get them for a good price and rent them out. When we see this, typically what I've seen and a reason where a landlord is not paying their assessments is one of a couple of reasons. One, someone who bought it out of a foreclosure sale, like a sheriff's sale, or maybe even a tax foreclosure, and never provided notice to the association that they're in there. Sometimes they don't even know that they're part of an association, as shocking as that is. But they never step foot in the place often, so they just buy it and start renting it out. And oftentimes, it's not until they get a letter from us, it'll be sent. Usually, if it's an LLC or a corporation, we'll look them up, we'll find out where their registered office is, and we'll send them a letter there. And then they realize, okay, here's what I have to do. Or sometimes they just don't care to pay the assessments and think they can get away with it, as shocking as that is. So obviously the best thing to do, you want to send that over to your attorney right away and take swift action, because we have seen situations, especially where the same landlord owns 3, 4, 5, 6 units in the same condo or 3 homes in the same subdivision. and they can rack up a very, very large balance very quickly. So, that's a reason to definitely stay on top of it and send those over to your attorney right away. Another reason I've seen this situation arise a lot, and it's caused some problems, but when you switch from one management company to the next, we've seen a lot of people become delinquent, and really not necessarily by a fault of their own, but oftentimes people are set up on an auto pay or ACH payments, where every month their assessment just comes out of their bank account. And they probably set this up years ago and never even thought about it again. But when the association switches to a new management company, it's a new bank account typically that management company is going to direct the funds going into. And so they'll cancel or put a stop payment on the prior ACH form, and they'll send out a new form, usually with the welcome email that says, hey, we're the new management company, here's our contact info, and here's a new ACH form. A lot of people don't look at that and don't realize that their prior form was cut off. And so I've seen multiple situations with multiple different associations that I've represented where this happened, and we had 7, 8, 9, 10 people who got delinquent and had no idea that they were delinquent because they never look at their statements to notice that their payment of $300 a month or whatever it may be is not getting to the association. So we've dealt with that situation, but it's something to be mindful of because it does happen from time to time. Another reason we see a little bit less often, but we've dealt with this several times, is somebody passes away. Unfortunately, they may not have anyone else who's living in the unit or who checks up on them regularly, and somebody may not know about it or deal with it for several months. And you have a unit that oftentimes they're owned free and clear with no mortgage on them, but the person passed away, and for whatever reason, there's not another family member there who's taken on the expenses or come up with a plan to either sell the property or move in and pay for it. And obviously in those situations, you're not going to get very far by sending a demand letter. So of course, what you want to do, make sure you put your lien in place right away, because eventually someone's going to sell that property. And with your lien in place, hopefully you can get paid. And then we've got our favorite group, which is the repeat offenders and people who for no rhyme or reason just continuously become delinquent. They pay it off after it goes to legal or to collections, and then lo and behold, after a few more months, they're delinquent again. I can't tell you how many files I've had where I've gone after the same owner for collections. They end up paying the legal fees, the late fees. Maybe there's a lien on their home. Eventually they pay it off, and then 6 months later, the association or the property manager sends me an email and says, hey, this person's delinquent again. Go ahead and start collections process all over again. And obviously those people you're not going to necessarily be as lenient with when it comes to a payment plan or waiving late fees as you are with people who just lost a job or had an unexpected medical expense.
Brandon, it looks like you have 2 questions in the chat based off this slide.
All right, very good. So let's see. So, all right, so I have a comment asking if I have a headset because there's quite a bit of feedback. I apologize, I do not. If the quality is still poor, let me know, and I'll try and play with this a little bit. But I apologize for that. So I have a question that says, who or what is the appropriate person or entity to begin the action of collecting from delinquent members? It's a good question. Usually if you have a property manager, usually the way the process goes is the manager is going to be on top of it and say, hey, this person is 2 months delinquent. We've sent out our standard notices and we've gotten no response. And we'll make the recommendation to the board that it be referred to the attorney. And then obviously the decision is for the board. So you would need a majority of the board. If you have 3 members, you need 2 out of 3. If you have 5, 3 out of 5 to agree to recommend moving that account over to the attorney and letting them start the collection process. And I have another question that says, are there any Michigan COVID emergency rules that allow co-owners to forego paying assessments? Another very good question. Right now, there's not a rule that says people are allowed to stop paying their assessments. There are some rules that I am going to talk about a little bit later on about foreclosures and evictions. But with respect to condo associations, there's nothing out there right now that allows people to stop making their payments. So as of right now, you're still responsible for your payment every month, even if you lost your job or lost your business due to COVID. Those are very good questions. All right, so talk a little bit about another situation sometimes why people get delinquent is people who are angry and purposely say, I'm just going to stop paying for whatever reason. A lot of times it's the association went after them for a bylaw violation. They're not happy about that. So their response is, I'm not going to pay my assessment. Another situation is when there's a large additional assessment or special assessment. For example, the roads. We see this a lot of times where communities have to generate a lot of money to pay for their road maintenance. We've seen some situations where an additional assessment is in the amount of several thousands of dollars. People get angry and they say, I'm not gonna pay it because I'm mad at you. And then obviously the situation where a maintenance dispute, owner says, hey, I want this done to my building, or I think this needs to be repaired. And for whatever reason, the association's not doing that. They get mad. And again, the defense is, I'm not gonna pay. So a question we get all the time is, are you allowed to do that? Are you allowed to do that? Or we get from co-owners sometimes who say, I'm gonna escrow my payments. I'm not gonna pay them due, but I'm gonna escrow them. Well, legally, under the Michigan Condominium Act, you're not allowed to do that. So whether you're receiving the services that you think you should be receiving or not, whether you're escrowing your payments or not, and whether you think that the association's done something wrong or failed to maintain something they're supposed to maintain, that's not a defense. You have to pay your assessments every single month. And legally, saying that you escrowed them is not going to be a defense to having to pay late fees, having to pay attorney fees, and potentially being foreclosed. So that's specifically from the Condominium Act. If you're a subdivision or a homeowners association, there's actually not a specific act or statute in Michigan that governs those types of associations. So it's just going to be in your documents, but I've never seen a declaration of restrictions or any set of governing documents for a subdivision that allows owners to escrow assessments or withhold assessments because they're unhappy about something. So, this is bottom line, it's not a defense. And if people raise this as an issue, that should not deter you from a board from taking swift action to collect. All right, so collection policies. Some of you have collection policies. I know I would say on average, probably 50-50 of our communities that we deal with have collection policies, the other half don't. We always recommend, if you don't have a collection policy, to adopt one. And you might ask why. A couple different benefits. First of all, your collection policy is going to break down usually in a couple of pages as opposed to 80 pages of bylaws, but put everything in one place. It's going to say, here's our framework. Here's what we do when you're delinquent. We'll give you a timeline. 15 days late, you get a letter from the management company. Okay. 30 days late or 45 days late, you get a second letter from the management company. If you're more than that, it gets referred to the attorney. And we'll kind of walk the owners through the whole process step by step so that, one, it's very easy to understand. Two, it's clear, and importantly, it treats everyone the same. It says, this is our policy. This is what we do for everyone. We don't pick and choose who we send to legal. We don't discriminate. We don't play favorites. If you're late by X number of days, this is our policy and this is what we do. And this is really to protect you as board members from the argument of, hey, this board took action against me. They put a lien on my property, but my neighbor down the street, who's best friends with the board president, hasn't paid in 4 years and they're not doing anything about it. So having a collection policy and being able to follow it is going to protect you as a board member from someone potentially making an argument that you're discriminating against them or playing favorites. So again, your collection policy is also helpful because to talk about, here's what we look for on a payment plan. So for example, if you guys as a board have decided that all payment plans must be paid off within 12 months, let's say, you can put that in there, and that at least sets the expectation for owners that you're not going to come in here and ask to pay $50 a month when your balance is $2,000. It'll never get paid off. So putting those things into place, setting the expectation, and making sure that everyone's being treated the same way are your keys on any collection policy. And the other thing to keep in mind, your collection policy has to be consistent with your documents. So if your bylaws say any assessment not paid by the 10th of the month incurs a late fee in the amount of $25, you cannot put a collection policy out there that says a late fee is going to be $100 because the documents, your bylaws say it's $25. So it cannot conflict. Now, a lot of times your documents may say a late fee will be set in the amount to be determined by the board of directors. And if that's what your documents say, that's great. It gives you guys flexibility, and the board can pretty much decide whatever they want as long as it's reasonable and put that in your collection policy and change it from time to time. If you realize $25 a month isn't enough, you don't have to go through the hassle of getting an entire vote from the whole community to amend your documents. You can actually just update your collection policy and change that. So you want to make sure your attorney is reviewing those and drafting those, though, to make sure it's consistent with the law and to make sure that any new updates are going to be taken into account. Looks like I do have a question. So I have another question that says, can an association withhold or terminate rights to certain amenities due to delinquency? Great question. Depending on your documents, yes, you can. And I'll get into that a little bit later. I actually have a slide on it, so hold that thought. So I want to talk a little bit about the timeline. Someone becomes delinquent, what happens next? Typically, if your payment's due on the 1st of the month. If the payment's not received by the 15th, usually your management company or your board, if you're self-managed, send out a standard delinquency letter. It's a cut and paste, it's the same letter that goes out to everyone. You just put their name on it and put the balance. If that doesn't get paid and now the second month comes in and they're now 2 months late, you're at 45 days delinquent, you're gonna want to send a second letter. And this is typically where I recommend checking your records to see, one, do we have an offsite mailing address for this person? Maybe they didn't get the letter, maybe they're not living there. And we want to look into that to make sure that they get the letter so we don't spin our wheels if we actually find out later, hey, this is a tenant that lives here and they're not opening the mail, we need to send this to the landlord. And also that's why I recommend having email addresses if you can get them, sending someone an email that says, hey, sent you out a letter in the mail. We didn't get a response. Just want to make sure you got it. Here's a copy of the letter because your payment hasn't been received. Friendly email, and that way you know they're going to get it. So definitely helpful. And if you still don't have a payment and now someone's more than 60 days delinquent, you're going to want to send that over to your attorney's office at that point. And your attorney is going to send a demand letter. And at that point, your board or your property manager should not be communicating with the owner. Everything should go through the attorney. We'll talk about why that is a little bit later. But we're going to talk about, next slide, a couple things that you don't want to do as a board member when someone's late or delinquent. And here's just an example. You don't want to draw attention to them or try and embarrass someone in front of the community because it's never going to be a good result. But here are some of the things that you shouldn't do. So number one, I've seen it before where someone says, hey, can we put out a list that says everyone in the community who's delinquent, right? And the rationale is we all live here, we all pay our bills, and if one of our neighbors isn't paying, we have to pay extra to make up for it. And that's not fair, and we should be able to know who's not paying. Totally understand that. But at the end of the day, there's nothing that legally prohibits you from putting out a list, but that's just a recipe for disaster. When you do that, you embarrass someone or try to shame someone in front of the entire community. You're just asking for a lawsuit or asking for a bunch of trouble. Same thing goes with sending an email blast to the whole community that says, hey, so-and-so hasn't paid their bill. Let's all go harass them. Bad idea. Never, ever recommend that. And number three, I know some of you guys do this. I always try and tell my board members, don't do it. But I know a lot of you like to say, yeah, well, I live right across the street from that person. If I see him at the mailbox, I'll go talk to him about it. You got to be really careful about this. You don't want to confront someone face to face, and especially if, non-payment can be an embarrassing subject for people. You don't want someone to get angry or have a negative reaction, especially in public when you're right there, by you confronting them about being late on their payments. So just deal with it the right way. deal with the attorneys and deal with letters and your property manager, but try to avoid personal contact because it's almost never going to end well. I may have another question. So I have I have a question saying, would sending arrear letters via certified mail solve the issue of homeowners saying they never got the letter? Good question. We see this all the time too. The problem with sending it certified mail is that they have to sign for it, typically. And so if someone's working during the day or they work long hours and they're not at home when the post office comes by, they're never going to be able to get that letter. It's also more expensive and time consuming to have to do it that way. I can tell you, if you are going to send certified letter, you should send certified and regular first class mail. So that way, if they don't sign for the certified, you'll at least know that they got the regular, unless the regular mail was returned as undeliverable to you. And that way you would know they didn't get either of them. But for our office, typically our initial demand letters are just sent regular mail. If there's no response to that, we send our second letter, which is when we enclose a copy of a lien, we send that certified and regular to try and avoid this exact argument. But I don't think it's necessary at this stage where you guys are just sending out a 15-day delinquency or a 45-day delinquency. I would say it's better use of your time and effort to check for an email address or something like that instead of spending the extra money for certified mail on something like that. But really good question. Getting back on the time frame, when do you want to get your legal involved? Well, like we said, by the time you're 60 days delinquent and there's been 2 prior letters sent by either the board, if they're self-managed, or your manager, at that point, if someone's not paying, it's becoming a problem and you need to address it sooner rather than later. So we typically recommend by the time you're in your 3rd month of non-payment, which is 60 plus days, send it to the attorney and let them get involved to nip it in the bud. So if you're a condo, say you're $300 a month, by the time you get to the point where you're sending it to the attorney, you've got $900, right, for your 3 months of assessments, plus probably at least 2 late fees, maybe a 3rd late fee coming up soon. And then, of course, at that point, you're at almost $1,000. So you want to get your attorney involved. If you're not a condo, or even if you are a condo, if you're a site condo, maybe you have a really low annual assessment and it's only $300 or $400 a year, you're not going to necessarily spend money on an attorney if someone's 60 days late and all they owe is $300. I actually have some communities where their annual assessment is less than $200 for the year. And so for them, it's not worth it to pay $200 for an attorney to send a letter when the underlying balance owed, if it's only 1 year, is less than $200. I completely understand that. But what I do recommend, if you are an HOA or just an annual assessment, really low dollar amount, if someone gets 2 years late, you should probably, at a minimum, just put a lien on the unit or on the home, even if you don't want to spend money to take further action. At a minimum, get your lien in place. That way, if they try and refinance, if they try and sell their home or anything like that, you can at least get paid out of the closing and keep your attorney fees to a minimum. So obviously, if you're an HOA and it's $600 a year and someone hasn't paid, a lot of my communities, they say, we don't want to send it to legal if it's only 1 year's worth. But once that 2nd year's assessment comes due and now they owe $1,000 or $1,200, that's when you're going to definitely want to send it over. So kind of depends on your community and obviously the dollars and cents we're talking about to make sure that we're not spending too much money to collect a very low balance. Looks like I have another question. So grab that. So question says, we sent registered instead of certified mail. Post office will deliver to address. Registered, it was delivered and does not require a signature. Does this add value? I do think that's worth it in certain situations. I'd want to know what the cost is to send a registered where they don't necessarily have to sign for it, as opposed to just sending a regular mail. I don't know that you need to be doing that on a 15-day delinquency status. Maybe if you wanted to, as a board, do that when someone became 2 months late. Okay, so $7 apparently. So yeah, I mean, in a one-off situation, it's worth it because you're going to add that back onto their bill anyway. But if you've got a community with, say, 300 units, I've got some that have over 600, 700 units. and you've got, let's say 50 to 60 people who are 15 days late, that adds up quick. So you got to depend on what's best for you and your community. If you're going to do it, like I said, usually you can bill those costs back to them as a collection cost, but there is also time and energy involved in doing it that way too. So you kind of got to depend. It might be worth it in your situation, especially if this is a repeat person. I'll say that if it's a repeat offender who's always late and in and out of collections, and the argument, I never got the letter, that's a situation where it's well worth it. But in a normal case, maybe not. It's a decision for the board. A great question. All right, so one thing to be aware of is there is a statute of limitations on how far back you can collect unpaid assessments. If you're a condo, you've got a 10-year statute of limitations, which is a really, really long statute. Most statutes of limitations in Michigan are a lot less than this. Oftentimes it's only 1 year, 2 years, or 3 years, depending on what it is. But this means if somebody doesn't pay an assessment that's due on January 1st, 2021, you can actually file a lawsuit to go ahead and collect that money 10 years later. So all the way up until January 1st of 2031, it gives you 10 years to take action, which is very good because you have a lot of time. But that being said, don't utilize all that time, because as we've said, the longer you go on and the higher the balance is, it's a lot harder to collect. If you are a subdivision, a platted subdivision, your statute of limitations, at a minimum, it's going to be 6 years, which 6 years is Michigan's breach of contract statute of limitations. So sometimes, for example, if it's just a once annual assessment, I've represented quite a few subdivisions that have said, hey, we've got these people, our assessment's only $300 a year. We've got people who haven't paid in 7, 8, 9 years. Here are the people, can you guys go ahead and collect it? And we've looked at it, and in certain situations, depending on the deed, when that person bought their home, you might be able to stretch it to 10 years, but in some cases you might not. And we've had instances where the association actually could not go back and recover anything that was older than 6 years because it's past the statute of limitations. So you don't want to sit on these things for too long. That's why it's important to definitely get your liens recorded and take action quickly. Now, once you actually refer it to the attorney's office, what happens? I'm going to walk you guys through the legal process. And a new file comes to me. Property manager says, hey, we've got this account. Here's their ledger. Go ahead and start the collection process. Well, the first thing I'm going to do is a title search. So I'm going to actually go into the county records and figure out on paper who owns that property. A lot of times I'll get a ledger from the management company that says John Doe, owner of this property. And when I go do the records check, it's actually not John Doe who owns it. It might be Jane Doe, or it might be John Doe and Jane Doe, or it might have been put into an LLC or a trust. So there are a lot of different things. And when I go to send a demand letter, I need to make sure I'm sending it to the right person. Because the only person who's legally responsible for that debt is the person who owns that property at the time the assessment came due. So the first thing I'm going to do is a title search. I'm going to figure out who's on the deed and who owes the money. And the second thing with a title search, I'm going to figure out what are the lien priorities. Is there a mortgage on this unit? Is there 2 mortgages? Are there unpaid property taxes? You know, where is the association going to be stepping in line? Obviously, if I get a file and for whatever reason the balance is high, say owner owes $5,000 in unpaid assessments, and I do a title search and there's no mortgage on the property, that's fantastic for the association because you're going to have no problem getting paid. And in that case, I might say, let's put a lien on immediately to get that first priority position. And I'll talk about this a little bit later, but Michigan, the way it works in Michigan is with priority for most things, whoever records their interest first is going to have priority. So if my lien is recorded before a mortgage, I have full priority. That means the association will get paid first out of a sale or a foreclosure, or anything before the mortgage company gets anything. So lien priority is a big issue, and that's something we'll look into, and we'll say, hey, not only do you have the wrong person on title, but here's the lien scenario. And that's helpful for a number of reasons. So number 2, what we're going to do, we're going to check bankruptcy records to make sure the person's not in active bankruptcy. And this is important because under federal law, if someone's in bankruptcy, you are not allowed to take collection action against them. There's something called an automatic stay. So you can't send demand letters, you can't put a lien on their property, you can't file a lawsuit. And obviously, if you do that and someone is in bankruptcy, you can be subject to some very stiff penalties, including court sanctions. So you want to make sure that you check the bankruptcy records, which is what we always do before we take action. Number 3, we're going to check the property tax records for the city or the township. You guys can actually look this up online yourself. There's a website, it's bsaonline.com. And most municipalities in Michigan actually do have their records available on there. Let's say your property is located in Farmington, Michigan. You can go into bsaonline.com, search for Farmington, Michigan, and type in the address of the property. Some cities give you a lot more information than others, but for the cities that give you a lot of info, sometimes you can find out the legal description for the property, the name of the current owners. You can see all prior history. And the big one is you can see what address they have on file with the city to receive their tax bills. And when I check these tax records, a lot of times I will find an off-site mailing address as to where that homeowner has told the city they want their tax bills sent to. And when I see that, that's often a dead giveaway that someone's renting their unit out and never told the association about it. Or potentially they don't live there full time. Maybe again, they're a snowbird, but it gives us another address to send to that the association may have had no idea about. So now when I send my demand letter, I'm going to send it to 2 addresses: the property where their unit or home's located and the offsite mailing address. And there's a better chance that they're going to get one out of those 2 letters. So number 4, we're going to review their ledger and make sure all the charges are accurate. I see a lot of times where the interest rate on the ledger is wrong, the late fee amount is wrong. Sometimes there's an additional assessment on there that may or may not have been appropriately allocated. So we want to go through the whole ledger that we get and make sure all the charges are accurate. And one thing I'll talk about again a little bit later is fines. We see fines that are on ledgers from time to time, and those are also very tricky. You want to make sure those were done the right way. Once we've done all that, we send our demand letter. We give them 35 days to pay the full balance, which is what we're required to do by federal law in the first communication, because what we're doing as an attorney is technically considered debt collection, consumer debt collection. So we have a lot of laws we have to comply with, and one of those is to give them at least a 30-day period of time on the initial communication to dispute their debt. So we'll send them that demand letter, and we do include our legal fees in that demand letter when we say, here's your balance. Just so you guys know, the cost that we charge for all of these steps, 1, 2, 3, 4, 5 on an initial letter is $200, and that would get added onto their balance. So if they owe $1,000, we send them a letter that says it's $1,200, including your attorney fees. And that would be the 35 days that they have to make payment. I do have a couple questions, so let me get to those. All right, so I have a question. It says, our nonprofit HOA documents state that dues or liens run with the land. Deed restrictions, any difference in years collectible? It's a good question. To tell you, I'm not going to be able to answer your question just based on what the deed restriction or your documents say. What we have to look at to determine if you have a 6-year statute of limitations or the 10-year is the actual deed for when the person acquired title to their home. So you're going to have to look at those individually by each owner. And as crazy as it sounds, some owners in the same subdivision may only be subject to a 6-year, while others may be subject to a 10-year, depending on the wording in the deed when they bought their actual home. But very good question. Another question I have is, what if a mortgage lender has first priority on a foreclosure action and the association's lien is a junior interest? Does the condo association have to hope that the senior lien is satisfied out of the proceeds of the sale? The answer is yes. If we have a junior lien and a senior mortgage or other lien forecloses, you don't get anything, and neither do any of the other junior liens like a second mortgage or a home equity line of credit Nobody else is going to get anything if the first mortgage company is not paid in full. The question continues, is the condo association out of luck if the proceeds are exhausted by the senior claim? Yes, that's exactly right. And can action be brought against the individual homeowners? Yes. So you wouldn't be able to collect your money from your lien if there's not enough money, but you could still sue the person in court and get a judgment against them personally. It's a lot harder to collect when you don't have the threat of foreclosure, but you could do a collection through garnishment, etc. And we'll talk about all the collection remedies later. But great question. Yes, you can still go after them personally, but you're not going to get paid if there's not enough money to pay off the first mortgage. So now getting back into calculating the balances. Again, one of the things I'm looking at, and any attorney is going to look at when you send them your ledger, they're going to make sure the statute of limitations is not an issue. They're going to take a particular attention to any special or additional assessments that are on the ledger. A lot of times your documents are going to include weird, unique rules about a special assessment. You know, it can only be X number of dollars per year, can only be used for these certain purposes, has to be approved by 60% of all owners, or 66%, or 51%. A lot of different rules. So if we see that, we're going to make sure that was done correctly. Late fees, of course, have to be reasonable. So making sure that your late fee that you're charging is consistent with your documents and that it's reasonable. Again, I've seen scenarios where I get a ledger and they're charging a $50 a month late fee, but in the documents or the bylaws, it only says they're allowed to charge $25. So that's a problem. That's something we're going to have to look for before we send a demand letter and make sure that the association's not trying to charge something. And it's usually inadvertent. It's almost always, it's just, you know, they didn't know, but we need to make sure that it's done correctly. Otherwise, we can get in trouble for collecting something that legally we're not allowed to collect. Interest, another big one. We see a lot of documents that say if you don't pay assessments, you can charge interest up to 10% or 15%. You can't do that. In Michigan, legally, the maximum you can charge as an association, in this case, would be 7%, and it has to be in the contract or your bylaws if you're going to charge that 7%. There are different rules for interest rates with regulated lenders or corporations for business purposes. So this 7% rule doesn't apply to, obviously, credit cards or commercial properties or business loans or things like that. But for this scenario, 7% is the most you can charge. So if you're charging more than that, you may have to completely remove all of the interest. And then obviously fines. I do have another slide that talks about fines, but fines, we have to make sure that they were done correctly before we collect them. And more often than not, I would say probably at least 70% of the time, when I see fines on a co-owner's ledger, the fines end up coming off because they weren't done properly. It's very difficult to, well, I shouldn't say difficult. It's very technical of a requirement you have to comply with. And a lot of times communities just don't comply with it. So I'll tell you guys how to do that correctly. And then obviously the last one, collection costs. I'm seeing a lot more recently over the past couple of years that we didn't used to see as much. Management companies are charging a fee every month when homeowners are delinquent. And sometimes they call it a rebill fee or a delinquency processing fee or a statement billing fee. And usually it's just sometimes it's $5 a month, sometimes it's $30 a month. But it's typically just a fee that the management company charges every month to send out a statement or a delinquency letter to someone who's delinquent. And as long as your management agreement says that those costs are actually billed to the association, and as long as your bylaws say that you can recover all collection costs, you should be okay to get that money back from the homeowners. But it's just another little weird thing that we have to look at to make sure it's done correctly. So here's the deal with fines. Most, and this is really only applicable to condominiums. So if you're a homeowners association for a subdivision, most of the time you don't even have the right to fine. You can fine if it's in your documents. And if it's in your documents, all you have to comply with is what's in your documents. There's no separate statute or law that you have to comply with. But in my experience, it's very rare to see homeowners associations or subdivision associations with the right to fine unless their documents were done at a minimum in the late 80s or early 90s, if not even later than that. Most of the older ones just don't have that in their documents. For a condo, it's actually in the Michigan Condominium Act, and pretty much every set, not every, but the overwhelming majority, I'd say at least 95% of condominium bylaws do give the association the right to fine someone if they're violating the rules. So, for example, somebody is leaving their trash bin out all week long, and the bylaws say you can only leave it out on trash day, and you got to take it in either that day or the next day. And you've got people who just don't care and they leave it out all week. Well, it's not a major issue to the point where you're going to want to go pay an attorney thousands of dollars to file a lawsuit against someone. But you're going to want to take some action to send a message to get these people to stop doing that. And a great thing you can do is fining people. If it's going to cost someone $200 every time they leave their trash bin out, they're a lot less likely to keep doing that if they actually have to pay that money. But before you can fine them, here's what you have to do. It says in the statute, this is MCL 559.206, which you guys can see, you cannot levy fines until you've given notice to the co-owner that they're in violation and after you've had a hearing. So most of the time what I see, almost all the time, someone violates the bylaws, the management company will send a letter that says, hey, Article 4, Section 2 of the bylaws says this. You violated it. Here's a picture. If you don't correct it, we're going to fine you. And then the person doesn't correct the violation, and they send another letter a couple weeks later that says you've been fined $100. Well, you gave them notice, but you didn't have a hearing. Again, a lot of times we'll see the letters will say, if you would like to request a hearing or schedule a hearing to dispute this, contact us to do so. That's not good enough. You have to actually schedule the hearing, hold the hearing, and invite them to attend. If they don't want to attend the hearing with the board, that's up to them. But you actually have to hold the hearing. And if you don't, if you just give them the right to request it or the right to appeal it through a hearing after they've been found in default, those fines are no good. So keep a close look at that and make sure that if you guys are fining people, that you're doing it the right way. Otherwise, when you send it to an attorney to collect, we're going to probably tell you, hey, it wasn't done right. We have to write these off. All right, so talk a little bit about late fees. Late fees, like I said before, it's going to come from your documents as far as how much you're allowed to charge and sometimes from your collection policy. Late fees really should be viewed not as a source of additional income, but kind of as a bargaining chip. So someone gets late and they always want a deal, right? Everyone wants some kind of a break. And if it's depending on the circumstance, the board may want to offer to waive late fees, maybe not all of them, but maybe half in exchange for payment in full. If the person's never been late before, and the late fees, it is a little bit of extra money, but it's not in the budget, and you're not out of pocket typically by writing off a late fee, unless your management company charges you for that, which is a separate matter we'll talk about. But use late fees to your advantage, but don't view them as we have to collect every dollar of every late fee, because that's really not what they're there for. Especially if you're getting into a situation where someone's going on a payment plan or you're entering into a settlement agreement with someone. Use the late fee as to your advantage to either get someone to agree, someone who's been difficult or has a high balance, and obviously making sure that if they're on a payment plan, you can use as an incentive, hey, as long as you're on time, we will stop charging you late fees during the period of the payment plan. So be a little bit creative and make sure you're using it to ultimately do what you want, is to collect the underlying assessment. And of course, late fees have to be reasonable. So if your assessment is $300 a month and you're charging a $300 a month late fee, that's probably not reasonable. Most of the time, it's about $25. We have some that's more, and just because it's more, $100 a month late fee could be reasonable depending on how much your assessment is on a monthly basis. But you want it to be somewhat proportionate to the amount that you're actually trying to collect. So keep that in mind. It's got to be reasonable. I have a couple questions that came in, so let me pull these. All right, so first question. If the fines are related to not paying dues, do you still have to hold a hearing? For example, our HOA states a written warning for the first offense and 10 days to remedy, then a $50 fine after the second offense. Yes, even if the fine is for non-payment, if you're fining someone under what really is a violation of the documents, the violation being non-payment, you have to hold that hearing. It's no different for any other violation. Now, you can do a late fee and a fine. So your documents might say if you're late, you get a $25 per month late fee, and we can fine you. The $25 a month, the automatic late fees or whatever it is, those are fine. You don't have to have a hearing for those. But if you're fining someone under your violation policy and the violation is non-payment, yes, you have to hold the hearing. Second question is just to verify, a hearing must be held in order to charge any bylaw violation fine. That's, as long as you're a condo, the answer is absolutely yes. If you're a subdivision, it's going to depend on what your documents say, but usually for subdivisions that do have the right to fine, the document says something very similar to what Michigan's Condominium Act says, and it does require you to have a hearing. But for a condo, yes, absolutely. You cannot fine without having that hearing. Now, the way it works, we actually do have another presentation we're giving later the year just on enforcement of bylaws. So I'll get into this a lot more detail in that one, and you guys please attend if it's interesting to you. But when you are, levying a fine for a violation, sorry about that, just popped up on my screen. Yes, so you have an initial violation. What you have to do is hold the hearing. You send them notice, you hold your hearing. Sometimes they attend and dispute, in which case the board still makes the ultimate decision as to whether they're in violation or not. And sometimes, most of the time, they just never show up. Once you've established the violation at that initial hearing, if it's the same repeat violation, so for example, the person leaves the trash bin out and you send them the notice, you schedule a hearing, they don't show up, you hold them in default, and they keep the trash bin out and it just keeps happening every week, you don't have to have the hearing every week. You can continue to fine them from that point on under the prior violation that was established, but the very first one, you cannot technically hold them in default and start that process until you've had the hearing. If it's a separate violation, so say this person with the trash bin, has gotten their notice, they've gotten their hearing, and they've just continued to violate, and maybe they're now on their fourth violation, and they're getting charged $200 every week or every month. If they commit a separate violation, like they've got their dog out in the common areas and there's no leash on the dog and the dog's running around, separate violation would require a separate notice and a separate hearing and go through that whole process again. But yeah, once you've established that violation, then you don't need a hearing every single time. One more question just came in. Thanks for clarification between fees as stated in governing documents and fines for violation. Only second condition, fines require a hearing. That is absolutely correct. And then a question about mobile home communities. That's going to depend on, mobile homes have their own specific rules and regulations that cover them. But if it's a condo that is actually a mobile home community, the same rule applies. If it's not, there are some separate rules that apply to mobile homes, but we're not going to get into those right now. But if it's a condo mobile home, then yes, the same would apply. All right, so back to the payment plans. Like I said, payment plans are obviously beneficial to going through the legal process and spending more legal fees. A lot of times we send an initial demand letter and someone will say, hey, I know I owe $1,000. I can't afford to pay it all at once. Can we go on a payment plan? And our recommendation is always be reasonable. So if someone is making a reasonable request, work with them. It's better than paying more money in legal fees and racking up the bill to try and get money from these people, especially if they can't pay. So if someone lost their job or is going through a tough time and is making the effort to get on a payment plan, as long as it's reasonable, we recommend it, especially because it could avoid bankruptcy. And if someone goes into bankruptcy, the association may end up being out of luck on collecting potentially the whole balance. So if you can work with someone and avoid pushing them off the brink, you definitely want to do so. But with any payment plan, it's going to have to be documented in writing. You don't need a formal contract for them to sign, but at a minimum, email confirmation would be great. If it is illegal and has gone to a lawsuit, then obviously there's going to be a signed contract that your attorney will prepare. But if it's at an initial stage and a lawsuit hasn't been filed, a lot of times I don't do a formal contract. I will just send them an email and say, hey, pursuant to our discussion, you've agreed to this payment plan. It's $200 a month, paid on so-and-so date, and all the terms. And I'll ask them to send me a confirmation. And once they do, you're good to go. So, you know, what you want to do if you are a large community and have a lot of delinquent accounts, give your property manager or your attorney some discretion on what type of payment plans you guys will approve. I have a few communities who say, yeah, you know, if their balance is under $2,000, as long as they pay it off within 6 months, we're fine with it. You can do whatever you want. You can agree to any plan you want that's within those terms, and we'll be happy. And that'll save some time so that way you guys don't get bombarded with a million emails every time, hey, this co-owner wants this deal, will you guys accept it or not, and have to go through the whole process. And what happens on default, what we put into all of our payment plans, even really if it's not in there, if someone's on a payment plan and they default, you're going to have the right to just proceed with collections, and you don't have to continue unless there's some weird provision that in a written payment plan agreement. If someone defaults, you have the right to go ahead and proceed and start collecting again, whether that's a foreclosure or a lawsuit. All right, so we've sent out our initial demand letter. We gave them the 35 days to make payment. What happens when a homeowner doesn't pay within that 35 days? Well, your next step is we're going to send a second demand letter. We send this one certified mail, and we give them 14 days this time to pay. And we're threatening foreclosure. And what we're also telling them is, hey, you had your warning letter, but because you didn't pay, now we put a lien on your property. And so, you know, a lien, like we've talked about, it's similar to a mortgage. It is something that will run with that land and is going to protect the association's position. So you have a lien on a property, that's going to prevent an owner from selling that home to someone else or refinancing without the title company or a bank catching that lien and requesting a payoff. And a lot of times you'll get your money directly from the bank out of the proceeds of the closing. So that's what we do on a second step. We record a lien, send a second demand letter, certified mail, and threaten to foreclose if it's not paid within 14 days. So what you had here, Michigan law, I talked about this already, but we have what's called a race notice statute, which basically says the first person who records an interest in property will typically have priority over somebody who records after them. So if a first mortgage company puts a mortgage on a property and then the association records their lien after, association, you're in a second position. If the roles are reversed, then the association has priority, and obviously the mortgage would get paid after. So first in time, first in right, very important for priorities. This is why, especially when we do an initial title search and we say, here's the situation, there's 2 mortgages, there's unpaid taxes, so on and so forth. You want to make sure that you are taking the best action to protect yourself. So it may be in your interest to put a lien on immediately and just skip that first step. And that's what your attorneys will help advise you guys on. So I have a chart here that just gives a little bit of a breakdown on different types of liens and what the priority rules are in Michigan. So unpaid property taxes, that is top of the list under Michigan law. They get priority over everything, and it doesn't matter who records first or anything like that. So if someone doesn't pay their property taxes, typically it's a 3-year process before they actually get foreclosed and completely extinguished their ownership interest. But if that does happen, anyone else with an interest is wiped out. And so obviously property taxes take first priority. And this is a scenario where sometimes if the association has a first lien, you may pay off the unpaid taxes to protect your position and then do your own foreclosure. Otherwise, you could get wiped out and lose everything. So property taxes are number one. As far as income tax liens from the state of Michigan or the IRS, those, they do have priority, but only if they're recorded first. So as long as your lien is recorded first, you're going to have priority. So again, you want to make sure you get your liens recorded as quickly as possible. Construction liens, not really relevant to what we're talking about, but just so you guys know, a construction lien has to be recorded at least within 90 days after the last date in which the contractor does work or gives some kind of service to the building. And there is a conflict in the law where the law says that a construction lien has priority over all other interests that are recorded after the improvement to the property. For condo liens, actually, the Condominium Act says a similar thing and says condo liens have priority over all interests other than first mortgages, regardless of when they're recorded. So if there's a first mortgage recorded on a property and then a second mortgage recorded, and then after those two mortgages, the condo puts a lien on, even though the condo lien was recorded third, automatically we have priority over the second mortgage, which is a fantastic tool that Michigan gives to make sure you guys can collect your assessments. What we do in those cases, we send a letter to the second mortgage company and say, hey, we have priority over you, even though you recorded this a long time ago. If you don't pay us off, we're going to foreclose and wipe you out. There is a little bit of a conflict between who would have priority, a construction lien or a condo lien. And there's no case in Michigan that discusses it, but that is an open issue. So with respect to the item I mentioned with a condo lien over a second mortgage, let me clarify something. If a condo lien is recorded before any mortgage, then you have priority over all the mortgages. But if there is a first mortgage that's recorded before you and then a second mortgage comes in, regardless when that second mortgage gets recorded, you as a condo have priority. This does not apply to HOAs or subdivisions, unfortunately. But for condos, this is the section of the act that says that. And like I said, we've been pretty successful with sending letters to the second mortgage companies that say, hey, for example, someone buys a house or a condo, say they buy it and they get a $300,000 mortgage on it. And then they get a home equity line of credit or a second mortgage for $50,000 or $100,000. Well, even if the condo's lien is only $3,000 or $4,000, if we have the threat of being able to wipe out a $50,000 second mortgage versus the mortgage company just paying $3,000 or $4,000 and protecting their position, oftentimes these mortgage companies will pay it off. And really, they're foolish not to, because they're going to lose a $50,000 investment over a $3,000 lien. Doesn't make business sense. So that's why when I'm doing a title search, when you send a file over to us initially, when I see there's a second mortgage and it's a condo, we're making a note of that and we're going to plan for that if we have to put a lien on. I got a couple more questions. So let's see. All right, question. If the fine structure escalates, for example, $50 second notice, $100 third notice, etc., we don't need to have a hearing every single time between notices, correct? That is correct. You only have to have it the first time, which is usually a warning. And most of the time it says first violation is a warning, no fine. But yes, that's correct. You don't have to do it every time on the same type of violation. Next question is, say we have a chronically late payer for quarterly dues. They typically pay in full, but either 60 or 90 days late. If we file a lien for a late January payment and they pay in March, they request that we remove the lien for a month or so. They are paid in full, but then the whole late payment process starts again. Bottom line in this situation, can we keep the lien in place? No, if they're paid in full and truly paid in full, you can't keep the lien in place. Now, you can say if they want to pay, if they're trying to make their payment, you guys are incurring costs in recording a lien. It typically costs $30 to record a lien, depending on which county you're in. Wayne County is a little bit different. But most counties charge $30. We submit ours electronically. There's a $3.50 service fee to do it electronically, but it gets done quicker. So $33.50 if we're doing it. If you're incurring legal fees or collection costs, then you shouldn't discharge your lien until they've paid that off, as well as the late fee, as well as the quarterly assessments. But once they truly have a zero balance, even if you know, hey, they're going to be late again next month, yes, you have to take that lien off. So you cannot put a lien in place until they owe money. But one thing that you may want to consider in that situation is if your documents allow you to accelerate. Some documents will say, if you are delinquent, we can accelerate the remaining assessments for the rest of the year, immediately due and payable. So if you've got quarterly dues of, say, $500 a quarter due in January and then April and so on, and they miss the January payment, you can say, hey, you owe the whole $2,000 up front, and we're not taking that lien off until you pay it. So check your documents. You may have the right to do that. And that may be a scenario where you want to do it on a delinquent person, continuously or habitually delinquent person. So jumping back onto this slideshow, there is a case that from the Eastern District of Michigan that said that the condo association actually had full priority over a federal tax lien, including interest, attorney's fees, etc., because the condo lien was recorded before the IRS recorded the federal tax lien. And this was a weird case because federal law tries to say that IRS tax liens have absolute priority. But in this situation, this is why it's so important to have your lien recorded, because you may actually even be able to get paid before the IRS, which is rare. All right, talk briefly about what is a deed in lieu of foreclosure. We don't see this a lot with condo associations. This is more common for mortgage companies. A deed in lieu of foreclosure is a situation where someone's defaulted, and instead of going through the foreclosure process, the person says to their mortgage company, I'll just give you a deed to my house and I'll just move out, because usually they owe more on the mortgage than the house is worth. That's a situation where a mortgage company might accept that to avoid the costs of a foreclosure and the legal fees and the risk that the person's going to damage the property. It might be beneficial. For condo associations, we really never recommend this. There was actually a case that came out a couple of years ago from the Michigan Court of Appeals where a condo association took a deed in lieu of foreclosure. You can actually take a deed in lieu in exchange for an association lien. But in that case, the association actually, originally they had priority over the second mortgage, because like we said, in Michigan law, condos automatically have priority over a second mortgage. But once the association took the deed in lieu and became the owner, they now lost that priority because you don't have a lien anymore. You're now the owner. So really bad mistake the association made in that case. Not something we deal with a lot, but just to kind of be aware of it. All right, so talk a little bit, when we're going to collection, we've sent a first letter, they didn't pay. We sent a second letter and we put a lien on the property, they still didn't pay. What do? You have two options. Sometimes we'll send a third letter, but typically if you're done sending letters, you've got two options. You either file a lawsuit or you foreclose. Filing a lawsuit, again, everything has its pros and cons, but if you get a judgment, it's good for 10 years. You can try and collect it for 10 years. And if you need more than that, you can renew it and try and collect it for longer. If you get a judgment against someone, you are allowed to garnish their wages if you know where they work. The employer will have to pay you directly. You can garnish their bank accounts if they have a checking account or a savings account. You can send a court officer out to their house to seize assets. Sometimes it's a car, sometimes it's a boat, other personal property. You can actually send a sheriff in to go in and take those assets and sell them, auction them off to give you your money. So in a situation where a home does not have equity in it, a lawsuit might be beneficial because you can get a judgment and try and collect other ways. The downside with filing a lawsuit, it's very time consuming. You're looking at a minimum of a few months just to get the process started. You've got to hunt the person down, personally serve them with a process server. They get the right to hire an attorney, defend the case. Sometimes they file a counter lawsuit. Sometimes it's hard to find them and you have to ask the court for permission to do alternate service. It's expensive. You're going to pay a lot more money in legal fees filing a lawsuit than you are if you were going to foreclose. And the other thing, once you're in court, you're giving the owner the opportunity to contest everything. And you're not going to, A judge is going to have to approve, yes, the legal fees are approved. Yes, the late fees were reasonable. Yes, everything you did was necessary. So we really try and avoid filing a lawsuit unless absolutely necessary, just because it takes so much more time and is a lot more expensive. Now, in Michigan, under the Condominium Act, you are allowed to file a lawsuit seeking a money judgment as well as seeking a judicial foreclosure at the same time. And that's from the Condominium Act, which is a good benefit that you have if you want to file a lawsuit. You can somewhat do both, but filing for foreclosure in court is a much different process than doing what we call a sheriff's sale. So there are other authorities to support the fact that you could do both at the same time. Construction Lien Act, chattel mortgages. We're not going to get into that, but I do have it cited there in case anyone was interested. With respect to foreclosures, there's two types of foreclosures. You can foreclose what's called by advertisement, which is not through court. It's a sheriff's sale. It's where you publish notice of the foreclosure once a week for 4 consecutive weeks with usually a legal news or a newspaper. And then the county will schedule a date. Most counties have a day of the week where they do all their sheriff sales. And you go down to the county courthouse and it's an auction, and they'll auction off a number of properties. So that's foreclosure by advertisement. And it's a really quick and cheap, efficient way to get people to pay. Judicial foreclosures are when you go to court, kind of the first option we talked about, filing a lawsuit. You have to serve the person, and then you have to get a judge to approve to foreclose. So these are rare, but we do them when we are filing a lawsuit seeking a money judgment. We'll ask for both a money judgment and a foreclosure judgment, and you're allowed to do so under the Michigan law. Now, if you're looking at the foreclosure by advertisement, when comparing, do we sue someone or do we foreclose? It's a lot cheaper. It's only going to cost you probably about $1,000 to do the foreclosure by advertisement. That includes usually a couple $100 fee to the county newspaper, as well as the legal fees incurred. Really quick, you can get the whole process from start to finish done in about 4 weeks, whereas your lawsuit potentially could drag on over a year if the person hires an attorney and defends the case. And once you actually do foreclose, that person is facing the risk of being evicted, as they're not going to even own the home anymore. So there are some cons, though. The cons would be that if there's not a third-party bidder, the association is going to become the owner of that property. And what that means is the association is going to have to hold on to it until the redemption period expires, and then you can try and evict the owner. But when you do that, they no longer owe you a debt. So once the association forecloses by advertisement and becomes the owner of the property at a sheriff's sale, the association is basically buying the property for the amount that was owed. So if the association's owed $5,000 and you go to a sheriff's sale and no third parties bid at the auction, then the association is in essence buying this property for the $5,000 debt, and there's no more debt that they owe. So you can't collect that money from them. But if they want to get their property back, they have to pay you back that amount in what's called a redemption. So I have a couple examples here as far as should we foreclose or should we file a lawsuit. Here's a first scenario. Your association, you're owed $5,000 on your association lien. The property is worth about $100,000. There's no mortgage on it. There's no unpaid property taxes. I'm actually going to open this up to everyone on there. Any volunteers on what do you guys think we should do? Should the association in this case file a lawsuit or actually do a foreclosure by advertisement? I'll give you guys a minute to look at it. And if I have a volunteer, shoot me a chat. You should be able to unmute yourself. So I have a lot of comments in the chat saying foreclose, 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 or send the guy with the baseball bat to collect. I like that. I like that one. Baseball bat, yes. So the answer is, in this case, you guys are all right. You're going to foreclose. The reason there's so much equity in this home. There's $95,000 in equity. So if you foreclose, what's going to happen is all these third-party investors are going to show up and they're going to say, I can buy a property worth $100,000 for $5,000, and there's no other mortgage owed on it or taxes or anything else I have to pay. Absolutely. And that property is going to get bid up and it'll probably sell for $60,000 or $70,000. And the association is going to get paid in full out of that immediately. So in this scenario, you're right. You're absolutely going to file a foreclosure. Here's a different one. So let's look at example 2. Condo still owed $5,000. The house is still worth $100,000. There's a first mortgage for $90,000, and there's unpaid property taxes owing $15,000. So what do you guys think in this case? All right, I'm seeing a bunch of responses coming in on the chat. Lawsuit, lawsuit, sue, lawsuit, lawsuit, lawsuit. So yeah, everyone's on the same page and you guys are right. Now in this case, it makes sense to file a lawsuit because there's no equity. So if you do the foreclosure, nobody's going to buy this property knowing that it's only worth $100,000 and it's owed $120,000 in debt to various creditors, right? If you're going to pay off the mortgage and the taxes and the association, you need $120,000. The property is only worth $100,000, so no one's going to buy it. So what's going to happen if you foreclose is the association is going to end up becoming the owner. And you could either potentially get wiped out by that first mortgage or wiped out by the county or the city for unpaid property taxes. So it makes more sense to file a lawsuit here. But I will say there is a caveat. Sometimes we will recommend foreclosing by advertisement, even when there's no equity. And the reason for that is if we know this is an owner-occupied property, there is a very large amount of pressure you can put on someone by threatening to be able to evict them if they don't redeem and pay off this money in full. And oftentimes people, even if there's not an equity in the house, depending on the circumstance and how little or how much underwater the house is, they may pay it off anyways just to avoid actually going through the foreclosure process and losing their home. So most of the time it's going to be a lawsuit on this one, but it depends. So I got one more example for you guys, number 3. Let's take a look at this one. Same thing, condos owed $5,000, property's worth $100,000. There's a first mortgage of $80,000, second mortgage for $30,000, and no unpaid property taxes. What do you guys think on this one? And I should say, this is a condo, but both mortgages are recorded before the lien. All right, so got quite a few responses. Looks like everyone's saying lawsuit. Did get a couple of foreclosed. Couple people comment foreclose, couple people said lawsuit. So this one's a little bit of a trick question. You're going to want to foreclose here. And the reason, even though it looks like this property's underwater because you've got $80,000 on the first mortgage, 30 on the second, which is 110 plus 5 on the lien, that's 115 in debt and only 100,000 in value. The condo association's lien automatically takes priority over the second mortgage. So really what we're looking at is the 80,000 on the first mortgage is all that would get paid before us. And if the house is worth 100,000, we can threaten to foreclose or actually go through with the foreclosure and wipe out that second mortgage company. And most of the time the mortgage company will pay it off. So it was a tricky one, but that's the benefit of having a condo. So I have a chart here that talks about the redemption periods. Again, a redemption period is when a property does get foreclosed. There's a period of time before you can actually kick that person out. This is called a redemption period. So if you get foreclosed on your mortgage, typically in Michigan, if it's a residential property, you're usually going to have 6 months of time to redeem that property. And what that means is, let's say you fell behind on your mortgage You owed $150,000. Mortgage company forecloses. You have 6 months to pay the mortgage company that $150,000 plus interest and get your property back. And they can't do anything to you in that period of time, called the redemption period. Now, depending on how much is owed on your mortgage, your redemption period could be as long as 1 year in Michigan. That would be if you owe less than 66 2/3 of the original amount on your mortgage. But most of the time it's 6 months. It's more rare for someone to fall behind and actually get foreclosed on when they owe such a little amount on their mortgage. So typically 6 to 12 months. If it's a commercial property, then it's always 6 months. And if it's agricultural property, it's 1 year. And there is a special rule on abandoned property. If somebody's totally abandoned a property, you can actually shorten that redemption from 6 months all the way down to 1 month. We have one more comment. The condo association lien is senior to the second mortgage, even if the second mortgage was recorded first. Yes, that is correct. That is a special rule on condos. Condo lien always has superiority over a second mortgage, regardless of when the second mortgage is recorded. So if there is a second mortgage and you're a condo, one of the options to always consider is send a letter to that mortgage company and try to get them to pay. You'll be surprised more often than not, as long as you can send it to the right department and figure out who owns that mortgage now, which sometimes is difficult because they get sold and transferred to so many different people. And yes, that's going to be a good option to look into. So I want to talk a little bit about some additional things that you can do to try and collect your money. Acceleration clause. This is what I mentioned prior with the example of the person who fell behind on their quarterly dues. Every time they're late and then they pay it, but they fall behind again. Well, depending on if your documents say that you can do this, which most condos do. Again, HOAs, it's not as much of an issue because it's just an annual assessment anyway, most of the time. But if you're a monthly installment or a quarterly or a semi-annual, check your documents. Your bylaws may give you the right to accelerate if someone falls behind, and that can be a very powerful tool, especially if you have a landlord or an investor who owns a lot of units and you really want to collect the money or take strong action against them. Being able to demand the entire year be paid up front is a powerful tool that you oftentimes can do. Another thing is a rent diversion. So if you know that a property is being rented out and there's a tenant living there, this is typically only applies to condos, but you can send a letter to the tenant and say, hey, your landlord fell behind on their assessments. You are required under Michigan law to pay your rent to the association. And the landlord cannot evict you or consider you breaching your lease if you don't pay your rent to the landlord, but pay it to the association. In fact, if the tenant does not pay to the association can actually evict the tenant, even though they never signed a lease agreement or anything. So rent diversion, very powerful tool. If you have landlords, usually this comes into play where you've got landlords that own multiple units and aren't paying. Send rent diversion letters and let the tenants pay. They can pay it down really quickly, especially if the rent is $2,000 a month and your assessments are say $300 a month. You get a couple months rent payment from a tenant and that may pay off the balance right then and there. So here's the actual statute from the Condominium Act that says a co-owner has to do this when given notice. There are some technical requirements. So if this is going to happen, we typically recommend let the attorney prepare the letter, and then the letter can come from the association, but let the attorney at least prepare the language to make sure all of the requirements are in there. And like I said, if the tenant doesn't pay, you can actually evict them. Some other enforcement action, sometimes people don't care as much about this, but if your documents say so, you can prevent people who are delinquent from being able to vote, but they still get the right to attend meetings. They just may not be able to vote. That's not in the actual statute. This is totally dependent on your documents. So if your documents say you have to be in good standing to vote, then you can enforce this. If your documents are silent, you cannot enforce that rule. And everyone would get to vote or run for office even if they're late. And same thing, typically, if someone's delinquent, the documents may say you're not allowed to run for a board or be an officer. But if that's not in your documents, they have the right to do so, as strange as that is. And then the last step on some additional enforcement action, we had a question earlier about being able to cut someone off from, I think it was common area recreational facility. Again, this is not actually in the statute, but if you have it in your documents, and usually I don't want to say I've never seen it, but I can't recall a time I've seen this in a subdivisions documents. Very, very common for condominiums, where let's say there's a community pool or a fitness center, tennis court. If someone's in delinquent status, if your documents allow you to, you may be able to cut them off and prevent them from using it. The way I've seen this enforced is sometimes you need a key card to get into the clubhouse or to get into the pool, and you would deactivate someone's key card who's late on their payments. And a lot of times, I had a situation where somebody was delinquent for quite a while until the summertime came around and the pool was opening up, and this person was told, you're not allowed to use your pool and we're not going to activate your key card. That person paid up immediately because they wanted to use the pool. So it's worth looking into. Just keeping in mind, you cannot deprive someone from the ability to get in and out of their home. So if you are a loft style condominium, you can't prevent someone from getting into the elevator or getting into the front door of the building if that's the only way to get into their unit. You can't do that. But recreational facility, yes, you can absolutely do that as long as it's in your documents. Just keep in mind, if someone files for bankruptcy, you can't do this. This is considered a violation of federal law. You can't take a negative action against someone when they're in bankruptcy. So if they are in bankruptcy, this wouldn't apply. Another thing that we see in documents, again, usually only condos, the association may have the right to shut off utilities. So sometimes your association will provide water to all the units. And your documents, if they say so, someone's delinquent, you may have the right to shut off utilities. And that's another quick way to get someone to pay. Usually you've got to give them at least 7 days notice that you're going to do that. And again, if they're in bankruptcy, you can't do this. Keep in mind that due to the current situation, there are some special rules governing turning off someone's utilities. So because of the COVID scenario, this may not be something to use right now, but in the future, it's something to keep your eye on and could potentially be used. Again, not relevant for homeowners associations so much, but for condos could be a powerful tool. So I have a couple of questions. First question says, can you deactivate the key cards to work at certain but not all access points to the building? Great question. And yes, I have seen that happen. As long as your documents allow it, and as long as there's still a way for them to get in and out of their unit, you should be okay to do that. Now, depending on the specifics of your circumstance, I may want to know a little bit more about it before I tell you to go ahead and do that. But as long as there's a way for them to get in and out, you should be okay there. For example, no access to front door to high rise, but can still enter through side door. Yeah, that's a perfect example when it would probably be okay. Again, I want to know a little more before I give you the green light to do that. But as long as they're still being able to access in and out of their unit, especially you want to be careful if this is a scenario where maybe someone's disabled and needs to be able to get in to access an elevator if they're in a wheelchair or something like that, making sure you're not preventing them from doing whatever they need to be able to do. But yes, potentially you could do that. Another question I have, if the homeowner violates the master deed by building a fence without asking for approval from the HOA first, is it worth sending a violation letter to them if the fence is in line with the bylaws? Well, if your bylaws say everyone can have fences, but before you put one up, you've got to get our approval, and somebody doesn't get your approval but puts one up and it looks good, there's no issues with it, and you guys would have approved it anyway, is it worth sending a letter? Maybe, maybe not. I mean, you may want to send a letter just to let them know that, hey, before you make any type of exterior modifications, you need our permission. We know you put up your fence without getting our permission. You're required to do that in the future. If you're going to put anything up, make sure that you're aware you can't do that without our permission. I would certainly send a letter like that, but you're right. If you guys were going to approve it anyway, you're not going to make a huge issue out of it, but you want to at least set the standard So they don't think they have free reign to do whatever they want. You know, people may put up a bird feeder, or someone might try to put up a shed, or do something else that, you know, the board may not care about fences, but they may care about a shed. So it might be worth still sending a letter, especially because then if the neighbor next door says, hey, you put up your fence, did you have to get the HOA's approval? And he says, no, I didn't get anything. I just put it up and nobody said anything to me. Well, the guy next door may not be putting up the same thing. So you want to be consistent. I would still send a letter. It would just be a little bit of a different type of letter. So last question is, does this need to be in the governing docs, or is it a separate collection policy that has been written and distributed? Okay. I'm not sure which topic that's relating to, as far as if it needs to be in the governing docs. To the extent that's relating to cutting someone off from using common areas like a pool or a fitness center, yes, it has to be in your bylaws. You cannot add that to a collection policy. That's considered a significant change. And if you want to add that in, you'd have to amend your bylaws. So that's unfortunately not something you can do with a collection policy. All right, we are almost done. I want to talk to you guys about a program. It's called Step Forward Michigan program. A lot of my communities don't know about this. I want to make sure you guys are aware. A fantastic program that the state of Michigan does to actually provide financial assistance, to homeowners who have fallen behind. So this program actually is designed, this was created years ago. I believe it started in 2007 or 8, back when we initially had the first mortgage bubble burst. But the state of Michigan created this program to give homeowners the opportunity to keep their homes when they fall behind on either their mortgage payments, their condo assessments, or property taxes. And here's how it works. So this program provides interest-free loans of up to $30,000 to assist with whatever you've fallen behind on. And the way that it works is the money would come directly from the Michigan State Housing Development Authority. And it's technically considered a loan, but it's forgivable and the homeowner does not have to pay it back. So as long as you maintain ownership of your home for 5 years, that $30,000 is free money. And you never have to repay that debt as long as you comply with Michigan's requirements. So when we have associations who have people who've fallen behind and they say, hey, you know, I lost my job, this is my scenario, and they might owe a large balance, they may owe 6, 7, 8 grand. I'll recommend, hey, look into this program, Step Forward Michigan. You may qualify. I don't know if they will or not. There's some requirements that I'll get into, which are right here, but we'll recommend it. And I've been successful in a number of cases in collecting payments, some of them over $10,000 directly from the state of Michigan on behalf of these homeowners. And the way it works is the association, you fill out a simple application and there's no fee to the association. This, by the way, only applies to condos, unfortunately. So if you are a subdivision, you don't qualify for this. But once you get on the state of Michigan's approved list, which all you have to do is fill out the form, they will directly wire you the money. And anyone in your community can apply, and if they qualify, the state of Michigan will directly wire you the funds. So you get your money up front, and the state of Michigan is doing that as a service to homeowners who qualify. You'll see the requirements. You've got to be a Michigan resident. You have to own the property, so you can't be a tenant. It must be your primary residence, so this is not going to work on a vacation rental or a rental property that you rent out to someone. Importantly, you have to demonstrate an involuntary qualifying hardship. And the next slide talks about what those are. But that's kind of the toughest step that some people apply and don't qualify depending on what their situation is. You also have to demonstrate that you have the necessary income to make your payments in the future. So the state's not going to bail you out if it's clear that you're going to just default in a couple more months anyway. You've got to be able to show, hey, this was a one-time thing. Here's my scenario, but I have the ability to make my payments in the future. I just need help getting back on my feet. You can't have cash reserves of more than $10,000 to qualify, and you cannot have a conviction within the last 10 years of any financial related felony. Here are the qualifying hardships. So either job loss, a medical or a health event, death, For example, of a spouse would qualify, or someone who was helping to pay the bills, a divorce, or a one-time critical housing repair. Those are some of the things that will qualify you with the state as long as you meet the other requirements for them to give you this assistance. So this kind of just outlines what I talked about before. If a homeowner is approved, the funds are paid directly either to the mortgage company, the condo association, or the county for their payments. All you have to do is sign up to be a participating partner. Usually takes only a couple of weeks to get on the list. We encourage all of our associations to become participating partners. The flat fee we charge to do it is $350. Well worth it to get on that list. And something that we do when we're dealing with homeowners who say, here's my situation and why I'm not paying, if we think they might qualify, we'll tell them, hey, look into Step Forward Michigan and see if you can apply, because free money for them and the association can get paid immediately. So I'm going to be very brief on bankruptcy. Just so you guys know, there's two main types of bankruptcy that a homeowner would file. There are other types of bankruptcies, but for the most part, you're going to be dealing with either Chapter 7s or Chapter 13s. Now, Chapter 7 is a scenario where somebody is saying, I basically have no assets, or all of my debts far exceed my assets, so I'm giving up everything. And oftentimes this would include giving up their home. Sometimes they're going to keep their home even in a Chapter 7 and do what's called a reaffirmation. But regardless, a Chapter 7, if that happens, the association is going to get notice of it. They're required to send notice to all their creditors. Usually they'll go to the management company. You have to immediately stop any collection activity. So if you are in a lawsuit, you have to immediately stop the lawsuit. If you're foreclosing, you immediately stop the foreclosure. No more demand letters, no recording a lien, no cutting someone off from utilities, etc. In a Chapter 7, at the end of it, what's going to happen is all of that homeowner's debts, there are exceptions, but most of your debts are going to be wiped away. And so with respect to a condo association, if it's an unsecured debt where there's no lien on the property, they could potentially wipe that debt out entirely. In order to do that, they're usually going to have to give up their property, in which case you could not pursue them personally for a money judgment. But if they're keeping the property, you can still collect your money. There's ways around it. We don't see Chapter 7s a lot in representing condo and HOAs, but Chapter 13s is almost always what we see. And Chapter 13 is different. Chapter 13 is where a homeowner is basically going on a payment plan through the bankruptcy court to pay off their debts. And you might be able to cut out some of the money that you owe, but with a Chapter 13, you have to use basically all of your disposable income to pay off your debts. Same rule applies. You stop collection efforts immediately. These payment plans are usually 3 to 5 years. And what the association would do is file a proof of claim and then make sure that there's what's called a Chapter 13 plan that the homeowner files. And that's going to outline how the association is going to get paid back. So usually, as long as your lien is recorded, you should get paid back eventually. You may have to wait a number of months before you get paid back. But you're going to stop collection activities. And if you haven't already put it in legal, make sure your attorney gets the account at that time. I have a couple recommendations for associations and streamlining collections. This is big. A lot of the management companies already do this, but if you're self-managed, really consider utilizing or offering an ACH auto pay to your homeowners. You'll pay some money in administrative costs. You may pay some bank fees to process these payments, but it's going to make it so much easier to keep track of who's paid and to avoid everyone, mailing a check and taking it to the bank and losing it, and keeping records of everything. Giving the opportunity for ACH auto pay save you a ton of time. Another option, giving people the option to pay credit or debit card online. If you can do this, usually there's a transaction fee. You may pay a couple % on the amount, but it may be worth it for you to avoid all the postage costs and collection costs, etc. So a couple options to consider. Again, if you have a management company, they probably already offer those for you. But if you're self-managed, it's worth looking into. So now the last topic that we're going to get into is I'm just going to touch briefly on, the COVID situation and what does this mean for condos and HOAs. The law is constantly changing in this area almost daily. There's executive orders being issued by Michigan's governor, Gretchen Whitmer. There's executive orders being issued by the president, Joe Biden. The Centers for Disease Control recently issued an order in September 1st, 2020 that prevented landlords of residential property from evicting certain covered persons. And this order was adopted by the Michigan Supreme Court. So this is being enforced in Michigan. That was originally set to expire, I believe, December 31st, 2020, but that was extended. That was recently extended to go through March 31st. So that's currently in place. And this may not apply so much to associations because you try to collect assessments, but where it does come into play is if there's a tenant and the association is doing a rent diversion, you're going to want to make sure you comply with this. Just so you guys know, for your own knowledge, these are the covered people in order to obtain this forbearance from getting evicted. You've got to be using your best efforts to obtain government assistance. You have to earn no more than $99,000 in income as an individual. You have to be unable to pay your rent due to a loss of household income or a loss of work. You got to be making your best efforts to make timely payments, either partial or full payments as close as you can. And if you are evicted, it has to result in this person essentially being homeless. So if those requirements are met, there's a couple other requirements you have to, here are the exceptions. You can still be evicted. First of all, let me just clarify, this doesn't apply to any commercial properties. So only residential properties, and only if the person meets all those qualifications on the last slide. You can still evict them if they're doing any of these items, criminal activity, creating a safety risk, or if they're damaging the property, you would still be able to go ahead and evict them, even with what's going on right now. But the tenant is required to fill out what's called a declaration to the landlord, telling them that they meet all of these requirements. And if you do receive that as a landlord or as an association who was trying to evict a tenant, you've got to make sure you comply with it. There's some severe penalties for failing to do so. So for the most part, evictions are not often used by associations, but that's the current status of the law on them. I have a couple questions. In the case of a Chapter 7 or Chapter 13, if you have a lien filed prior to bankruptcy, how is the lien handled by the bankruptcy court? Great question. So as long as your lien is recorded, you're considered a secured creditor. That means in a Chapter 7, the homeowner is not going to be able to wipe your debt out and keep the property. The only way they can keep the property is if you're going to be getting paid. With respect to a Chapter 13, the same thing kind of applies, but in a Chapter 13, they're usually not going to wipe you out unless, again, you're considered unsecured debt. And even then, they're usually not able to wipe everything out, but what happens is sometimes unsecured creditors are the last to get paid. So if you don't have your lien recorded, you might not get paid in full, and you're not going to get paid early. That's for sure. If your lien is recorded, you're considered a secured creditor and you would get paid first. So if they have credit card debts and there's not enough money to pay everything, the lien would get paid before someone like a credit card company, because the credit card company is just unsecured debt. So good question. That's really important to have your lien recorded before they file bankruptcy, because once they do, you can't file it at that point. Next question is, a tenant not complying with a rent diversion can or cannot be evicted at this time? Good question. It's not a simple answer. It's possible that you could evict during this time, but you're going to have to make sure you comply with all of these requirements. So not necessarily an easy thing to do. For the most part, we're recommending not to do this in these situations because a lot of judges are being very sensitive to homeowners during this time, and oftentimes are not actually enforcing the rule the right way. But it is possible. under the right circumstances. So it's going to depend on the situation, and we have to look at that individually to let you know. If it's a matter where it is in active litigation, that's another scenario where we're probably not going to recommend doing an eviction or taking some kind of action like that if there's already an active litigation involved. So most judges are not going to be fond of that. When there's an active case, they're going to want to defer to the judge that's already presiding. So great question. Now, on the opposite side, with respect to foreclosures, there are some foreclosure rules that have gone into effect. Again, some were done by Congress in the CARES Act that was passed last year in March. A lot of those restrictions were going to expire, but Joe Biden has extended a lot of them. Right now, the way the law is there is a moratorium, so there's no foreclosures going on for federally backed mortgages. So federally backed mortgages is something like an FHA loan or a VA loan or Fannie Mae, Freddie Mac. Those are federally backed mortgages. That there's currently an extension. So Fannie Mae and Freddie Mac, those foreclosures are currently on hold through at least March 31st. The others are currently on hold through June 30th, 2021. And I would expect Fannie Mae and Freddie Mac are going to extend theirs to be in line with the VA and HUD loans as well. So this does not apply to you if you have a conventional mortgage like a Quicken Loans, Chase Bank, something like that. This doesn't apply to you. This only protects people with federally backed mortgages. So that being said, this law or these orders do not prevent a condo association from foreclosing. We're able to foreclose right now. And a lot of associations have asked us questions about, can we foreclose during this time? And you can, but the thing to be mindful of is that even though we were allowed to foreclose, a lot of the counties in Michigan have stopped holding sheriff sales. And some counties haven't had any sheriff sales since last year in March, when the whole pandemic started. So right now, Wayne County, Oakland, Macomb, Washtenaw, Livingston, a lot of the bigger counties in the Metro Detroit area have not been holding sales. So even though as a condo association, you're allowed to foreclose right now, as a practical matter, you can't because the counties are not holding sales. So the only thing you can do is pursue your foreclosure in court through a judicial foreclosure, which is filing a lawsuit. And you can do that, but it's not as, this is not the 4 weeks publishing the notice and then having an auction style sale that we talked about. This is the longer process of filing a lawsuit and serving them and paying a whole bunch of money and giving them the opportunity to contest it. So you could still foreclose, but it's going to take you a lot longer. So my last slide, just a couple tips of during this time and what you can do as an association to try and deal with this situation. The first thing is increase communication and offer support. So we've been dealing with this situation for almost a year now, unfortunately. It doesn't look like it's going away anytime soon. A lot of people have lost their jobs. A lot of people are going back to work now, but a lot of people have lost their business. And what you want to do is, if you're noticing that people are delinquent, it may be worthwhile to send out a notice saying, hey, if you guys are suffering from a hardship due to COVID-19, reach out to us and let us know, and that way we can work with you. Getting in front of it on the front end is better than obviously letting someone fall behind several months before you take action. So increase communication, offer support. Number 2, you want to either implement, if you don't have one, or amend your collection policy. A lot of collection policies will say, hey, if you're not paid within X number of months, we will start a foreclosure or we will file a lawsuit. That may not be the best practice right now, again, depending on what's going on. So you may want to reconsider that and look at whether you need to amend your collection policy during this time. Number 3, waive interest, waive late fees. If you have people that you know are going through a tough time because of this, it may be worthwhile. You don't want to bury people who are really going through a tough time but are trying their best. It may be a scenario where you want to waive late fees or interest when you get someone on a payment plan or work with them. But again, you're going to want to continue to record liens. protect your priority position and protect against bankruptcy, like we talked about, and delay foreclosure for a reasonable period of time while you work with people. I do have a couple questions. I see somebody raised their hand and wanted to ask a question. Let me see. So I have a comment. Thank you so much. You're very welcome, Darlene. Thank you for joining. I have a hand raised. I don't see a name though. Are you unmuted, sir? You can ask your question. It seems muted.
Okay, I own a condo and I'm selling it on a land contract. I have not received any monies from them since July. They paid me half a payment in July. I'm currently paying almost $300 for the association charges that covers their gas, which they heat with gas, and the water. So the only thing that they're paying right now is their lights. And so they think that because of the pandemic that they're fine, even though they're receiving Social Security and their financial status has not changed. So like I stated, I haven't received any monies from them since July, and it was only a partial payment then. So what can I do? Just sit and wait or what?
Yeah, it's a good question. I completely understand your frustration. Just so you know, there's not a law right now that gives people the right to not pay. You may still have options on what you can do, but you're going to have to be careful with the land contract. Really not the proper forum for me to answer these questions, because it's going to depend on your situation, your land contract, the history, and I have to look at everything independently. But just so you know, legally, nobody is given the right to not pay during this time. So they still have to pay, but the penalty for non-payment may be different. So if you want to talk about your scenario, I would encourage you to call me in my office, and we can set up a time and talk about it. Maybe we can help you out. But with that being said, I'm more than happy to take any other questions that we didn't get to. It looks like I have a few in the chat, so I'm going to go to those. All right, so I have a question that says, will there be a copy of the webinar available? Yes, it was recorded. We will post it online on our website. And there should be a link that will go out where you guys can access it. In fact, we do that with all of our webinars. So that will be posted. And more than welcome to share it with everyone else in your office or on your board. I will stick around for a couple minutes just to see in case anyone else has a question. I'm more than happy to answer anything, but if not, thank you guys so much for joining. I appreciate your time. And any questions, you can always reach out to us. We're more than happy to help you. So, and have a great night, everyone. Thank you.
Thank you.
You're very welcome.
Hey, thanks very much.
Yeah, thank you very much. Anybody still there?
Yeah, there are actually quite a few people still on. You're very welcome, by the way. Look, we had at some point, I believe, about 40 people on. So
Yeah.
pretty good turnout.
Excellent information, very, very helpful. I have a question. I was attempting to record at the beginning, but I didn't want to interrupt with permission. Is there a chance that your presentation would be available to access?
Yeah, we do. This was recorded, and it will be posted on our website on herzellaw.com.
Oh,
it may take a few days, but check on herzellaw.com. Let me see if I can actually find. I'm just going to go to the website really quickly. Let's see. There should be a spot on the top for our presentations. Can you see my screen or not right now?
No, all I see is question and answers.
Okay. So I'm on our website.
Okay.
if you go to herzlaw.com, at the top
Okay.
right, there is a link called seminars
Okay,
at the top right. And that is where we post, that's where we post our seminars. So usually there's a Zoom link, and I will make sure that we do post the recording of it. If for whatever reason you're not able to find it, you can shoot me an email.
Okay.
And I'm more than happy to make sure that you get a copy of that.
great. Thank you very much. Appreciate
welcome.
your time and all the info.
Absolutely, you're welcome. Have a good night.
Thank you. You too.